I'm Rob Jasinski. This is Symposium, where we talk about the ideas at the basis of a free society. My guest today is Tim Sandefur of the Goldwater Institute, author of Freedom's Furies, which is a book. Thanks for coming on, Tim.
Thanks for having me.
Now, I mentioned your most recent book, Freedom's Furies. I'll give you a chance to talk about that later. I don't want to talk about that primarily today because I haven't finished reading it. I'm gonna read it, and I'll probably bring you back on if I can get you to talk about that. But the reason I'm having you on is that you wrote a very interesting article recently for Shikadalmi at the Unpopulist about the idea of substantive due process, which is one of the things that's fallout from the Dobbs ruling that overturned Roe v. Wade. And the concern for a lot of us is not just the issue of abortion, but also the legal reasoning behind that,
right?
And which I view, and I think you view, as being somewhat hostile to the idea of the Supreme Court as a guarantor of individual rights. And you were talking specifically about the reasoning in Clarence Thomas's separate opinion, striking down Roe.
Yeah, that's right. Justice Thomas is really the most outspoken enemy of a legal theory that lawyers today call substantive due process. And he used the opportunity of the Dobbs case to explain in his separate opinion why he thinks that theory should be completely thrown out. And what I argue in my article and in several other articles that I've written is that substantive due process is not only a correct legal theory, but is the oldest and most important of all of our constitutional protections. And it's a very myopic view, very short-sighted to say, well, because I don't like the way that this case or that case came out, we're going to erase this entire legal theory from our jurisprudence. Very dangerous idea.
Right, so let's talk a little bit about, just describe for us what substantive due process is. And by the way, one of the reasons I'm having you here is I've written some things about this, and a lot of my thinking has been shaped or reinforced by reading some previous things you've read. So I was really glad you have a new thing out addressing this. So just describe a little bit what substantive due process means. And it kind of seems like an oxymoron, right?
It does sound that way.
Is it substantive or is it procedural?
That's right. It does sound that way. Now, that is an artifact of the phrase substantive due process, which was invented really in the 1920s by enemies of this legal theory. So it's really not fair to say, well, it's an oxymoron. The oxymoron is in this slogan that the enemies of due process of law came up with. And so it's really their fault and it has nothing to do with the doctrine itself. What substantive due process really says is the Constitution says you can't be deprived of life, liberty, or property without due process of law. And those last two words are really the important part of the phrase. You can't be deprived of these rights unless the government follows a process of law, as opposed to some other kind of process, right? You could have a society where legal decisions are made by tossing a coin or consulting the zodiac or something. I mean, those may sound outlandish to you and me, but there really are societies that are like that even to this day. And what the Constitution says is you will not have to suffer a government depriving you of your rights under some process other than a legal process. Now, what is a legal process? Again, you said it sounds procedural, but if you think about it, process and procedure and substance, those boundaries kind of break down in the law. Take, for example, a trial, right? A criminal trial. We have this vision of you're arrested for a crime, you're put on trial. Is a trial a procedure or is it a substantive thing? You can sell your right to a trial. That's called a plea bargain. When you go and you say to the prosecutor, look, I'll give up my right to a trial in exchange for you bringing a lesser charge against me. You're basically selling the government your right to a trial, right? So if you can sell that thing, then that means it's a thing. It's a substantive thing. It's not just some abstract process. It's a thing in itself. And it's made up of things, including your right to call a witness or to testify on your own behalf. And you can waive those rights also. So it's a thing that's made up of other things. And each one of those things is a thing in itself, right? But you can also view it as a process, as a procedure, something like a dance. And the dance is produced by following the steps that are laid out in the instructions of how to do the dance, right? So it is a procedure and it's a thing in itself. So that you can see them back and forth as the same thing. That's why this whole procedure substance distinction does not make any sense anyway. What I see as the part of the aspect to it too is a lot of the procedures are themselves based on and make no sense apart from a substantive right that is embodied in that procedure. So, the right
the right to call witnesses is part of a substantive right that you have a life that cannot be disposed of arbitrarily, right? So it's your right to life that gives you all these other procedural rights.
And that word arbitrarily is the really important word, because what a due process of law is it's the opposite of arbitrariness. The opposite of law is an arbitrary action, or, being lawyers, we love to use Latin, ipsi dixit, which is Latin for because I say so. And the government just says, because I say so, that's why, like your mom did when you were 10, then that's the government acting arbitrarily without a legitimate reason behind what it's doing. And so in any kind of legal procedure, if your rights are being taken away, the judge has to decide whether the government is doing that for a legitimate reason or whether the government is doing it arbitrarily. And so that necessarily requires the court to decide whether there's a basic element of fairness, for example. That's just one thing, but fairness is a good example of the kind of characteristic that makes something a law as opposed to an arbitrary act. A good example from literature, in Alice in Wonderland, Alice gets drawn up before the court, right? And the queen pounds the table and says, punishment first, trial afterwards. Now, I think we would all say that that's not a real trial. That's just, it's a kangaroo court. Why? Because it's lacking in fairness. And so fairness is one of these elements that distinguishes a real process of law from something that's not a process of law. And yet Justice Thomas has said in some of his opinions that the Due Process Clause does not protect fairness. That's a really amazingly extreme proposition, and God forbid it ever become part of our constitutional law.
No, Thomas is just one guy, but I see this also as part of a wider thing. So what I noticed in the Dobbs decision, who was it who wrote the Dobbs decision? Was it Kavanaugh?
That was Alito.
Oh, Alito. I'm sorry. Yeah, I've got it confused. Okay, so in Alito's decision, in the decision he wrote, which is the one signed on by those people, what I found interesting is they also did this thing where they said, well, in order to find unenumerated rights, in order to determine what rights you have, the test they used from a previous decision about 30 years ago was that it had to be grounded in history and tradition or implicit in the concept of liberty. And so they quoted that. And then in his decision, he kind of dropped off the or implicit in liberty part, right? Because if you have grounded in tradition or implicit in liberty, you've got two different things you could cite. You could go one route or the other. You could say, well, no, this doesn't have a traditional grounding, but it's implicit in the concept of liberty, and here let me show why. But he sort of dropped off that second part and went to it's grounded in history and tradition. And I think that Thomas is doing something similar in terms of basically saying, unless the right is recognized traditionally, historically, then it doesn't exist.
Yes, that's right. There's a huge emphasis on history and tradition in his decisions. The gun rights case that came out in this same term as the Dobbs case is a great example of that. Great length that he goes to in studying all this history and looking into the past and all this sort of thing in order to determine what rights the Constitution protects. And there has always been this kind of tension between sort of a pure theory-driven idea of what due process protects, what's inherent in the very idea of freedom on one hand, which sounds very philosophical, and there's nothing wrong with that. Judges and lawyers are supposed to be philosophical. It's a shame that they're afraid of being philosophical nowadays, but that has always been on one side. On the other hand, there's this attempt to try and discipline the law and say, no, we're going to be very history focused in order to tie down the courts and the lawyers and make sure that they don't just run away and do whatever they want. And that back and forth has gone on for centuries. And Justice Thomas is very firmly on that tradition and history side. And by the way, the reason we're picking so much on Justice Thomas is because Thomas is one of the most philosophically astute justices ever to serve on the court, and I think is the most influential conservative justice, certainly at present, and possibly the most influential conservative in America today.
Well, and I had a lot of hopes for him because he actually is somebody who affirms the doctrine of natural rights. Right. So you'd think, okay, he'd be totally in favor of legal doctrines that are there to protect that. So let's back up a little bit on that, because you mentioned in your article, which I think is a fascinating little mini history that you give, of how basically the conservatives came to adopt the progressive view unconstitutional interpretation. That this idea that there's no substantive due process and the right approach is judicial restraint, where the judges defer to the legislature and basically don't create too many obstacles, don't find too many rights that will be obstacles to what the politicians and the legislatures want to do. That idea started out as basically, Oliver Wendell Holmes and the progressives who wanted to have no barriers to economic regulation. And then it became something that was adopted by the conservative justices.
That's right. When a side runs into a right that they don't like, then all of a sudden they switch. There's an old story. Abraham Lincoln used to tell this story about two men that he once saw get into a drunken fight in a bar, and they were so drunk that they didn't hurt each other. They had just somehow managed to fight into each other's coats. And he said the Republican and Democratic parties of his time had done something similar. Well, something like that has also happened among progressive and conservative legal thinkers. And there's a lot of history here. I mean, Justice Oliver Wendell Holmes, who's really one of the godfathers of this idea a century ago, one of his great admirers was Felix Frankfurter. Felix Frankfurter was the teacher of Alexander Bickel. Alexander Bickel was the teacher of Robert Bork. So you have this sort of laying on of hands of this judicial restraint idea that courts should stand back and do nothing when the government wants to take our rights away. And part of that has always been an outright attack on the idea of natural rights at all. That there are no such things as natural rights. Our rights are only given to us by the government when it sees fit. Thomas, as you mentioned, Thomas is unique in that he does believe in natural rights. He doesn't believe that our rights are given to us by the government. And yet he has he swallowed whole this anti-natural rights theory of attacking substantive due process that was created by the progressives. And those two things can't be reconciled. It creates a tension in his legal thinking that really is unsolvable. They're just inconsistent principles.
Right.
But I think if you're politically motivated, if you're politically motivated to get rid of some individual right that you don't like, in this case, abortion, but it could be gun rights or anything else, private property, then, you'll find some theory out there. And the one you find is, those activist courts, we got to rein them in. Those judges are, et cetera, et cetera.
Well, I think they were reacting to the sense that you had the living constitution theory, in the sense that you had a subjectivist theory, essentially, of constitutional interpretation, that whatever somebody would find in a penumbra of an emanation from a penumbra. Excuse me, it's hard to pronounce.
You got it right.
An emanation from a penumbra. It's
Which
not a word. Those words don't go together.
All it means is shadows from things.
Yeah, exactly. But, it's this idea that, the Constitution casts this large shadow, and then there's emanations from the shadow, and there's stuff that comes out of the shadows. And somewhere in there, I happen to find, the right or not find the right that I want to find or not find. And this sort of subjectivism to it, or Anthony Kennedy used to be, the sort of notorious as a justice for, he was the swing vote between the conservatives and the liberals. And it oftentimes just sort of seemed to depend on how he felt about a particular topic was how he ruled, whether he went with one or the other. So there is this sort of, I understand the sort of fear of a certain subjectivism that, lawyers and especially judges, and especially conservative judges, are fearful of the idea of, just opening up and playing it deuces wild, because that doesn't necessarily protect rights either, because you could find anything in the Constitution that means you could do anything you want. So I think what it is comes down to maybe is, and I want you to see what you think of this, which is, I think though that as conservatives, when they're trying to find a grounding, they're way more comfortable saying we're going to find our grounding in history and tradition and practice, rather than finding our grounding in a philosophy of individual rights.
That is exactly right. And it's the reason why that doesn't work is because our Constitution was not written on those premises. So our Constitution was written by people who believed that there were such things as moral truths, objective moral truths, not just mystical revelations, and who believed that there were such things as individual rights. So they devised this machinery that was supposed to operate with some of what we nowadays call living constitutionalism. But the reason why they why the founding fathers felt confident with that is because they thought, well, of course, rights are real things. They aren't just made up on the spur of the moment. Who would ever be so crazy to do that, right? Mm-hmm. And now, thanks to really about the turn of the 20th century, the progressive movement and that era embraced moral relativism and subjectivism, and the idea that things like rights are just sort of gut feelings and have no real more substance than that. And if you can't run the engine on that fuel, you can't run the U.S. Constitution on those kinds of premises. Yeah. So what conservatives have tried to do is they've tried to grasp onto tradition because that feels objective and real to them. And they're kind of right about that. The problem is that the tradition that in question is a tradition of natural law, natural rights, a more of an Aristotelian understanding of what human nature and human needs are. And they're not comfortable with that. They want this, more religious, supernatural approach. And those two things don't work. So the appeal to tradition turns out to be a masquerade. It turns into subjectivism, like with Robert Bork, who claimed, masqueraded as being this real moral authoritarian conservative. But when you actually read his book, he says morality is entirely just whatever you feel like, or not what you feel like, rather, what the majority feels like. And of course, we all know the majority always means everybody except you.
Well, yeah, I mean, part of the theory behind the living constitution was, well, it's the evolving standards of the evolving standards of decency in a modern society. Something afraid I don't have the exact phrase, but it's close to that. And the thing is, so it's the idea that the majority, the opinion of the majority is what makes for moral standards and for law. And of course, that the guy who wrote that didn't go out and actually do public opinion polls of what the majority opinion was in the country as a whole. He took a poll of people at the last dinner party he was at. It was very much reflective of the evolving standards of decency among my social circle and people who share my general outlook. So, but I think that, the interesting thing is the extent to which the conservatives are sort of adopting the same ideology, except they're saying, well, no, it has to be what the majority has thought for a long time. Right. It has to be what the majority thought in the middle of the 19th century. And I can find citations for what the majority thought about whether abortion was legal or whether gays had rights, et cetera. And that's, I think, what bothers me about it is if you have the idea that, we got to see to sort of rescue the living constitution from the subjectivist interpretation, the Constitution does need to be able to expand because there are rights that have traditionally not been recognized. Right. But which logically have to be recognized. And one example I think that's happened even within my lifetime, but especially before that, is, I talked to older people who grew up in schools where prayer and religious instruction was just a normal part of the public school. So I read something recently by a guy who grew up as a Jewish kid having to recite the Lord's Prayer at school every morning, right? And we would obviously see that today as a violation of the First Amendment, but it was something that, given the time and the place and the prejudices of the era, would not have been recognized as such.
Right. Yeah. Well, you cannot criticize an institution. You cannot criticize slavery on traditionalist grounds. It is absolutely impossible to criticize slavery on any grounds other than an ahistorical, philosophical, abstract, principle-based kind of argument. If you start pointing at history, there's no grounds whatsoever to condemn slavery because it's a ubiquitous human institution since the memory of man runneth not to the contrary. You mentioned the need for evolving standards. Yes, the law does need evolving standards. It's not what the subjectivists say. The subjectivists say justice itself evolves because there is no such thing really as justice. It sort of bubbles up from culture, and so it's relativistic to its time and place. That's an idea very associated with, although I don't think he specifically said it, but is John Rawls. And you find Rawlsian conceptions of justice absolutely inextricable from the works of people like Ronald Dworkin, who was one of the leading defenders of the living constitution theory. So people start thinking, well, living constitution just means this sort of there is no such thing as justice thing. So that I'm not that, so I can't be a living constitution person. If you took those things apart and you saw that what we're saying is that the Constitution, our understanding of what law means, does evolve over time, but the underlying rights do not, because human nature is human nature. It's objective, and it is understandable. We can understand. It's not just a bunch of philosophers throwing things at each other. There are truths to these things, and that means that there are right answers to legal questions. And that idea that there are right answers to legal questions is one that is rejected by both conservatives and liberals today, whether they know it or not. A lot of them don't know it. A lot of conservatives think that they don't realize that what they're saying is really subjectivism. But it really is, because if you think that the truth is brought to you through a supernatural revelation, There's no way to prove that to somebody who disagrees with you. And so it eventually devolves into either cultural relativism. Well, this is my faith. It may not be yours. Or into subjectivism. Well, I feel this is true. You don't feel this is true. We can't discuss the matter. Right. And so it devolves into subjectivism. What the founding fathers thought was that it would be an objective process of understanding reality, human reality.
Yeah. Well, and the conservative version of subjectivism is basically a kind of social or historical subjectivism. It's like our traditional culture and society believes this, so therefore it's what dominates. But what I want to sort of focus on is the extent to which, with all this appeals to history and tradition, as you've been saying, the contradiction here is that our tradition is a radical non-historicist tradition, right? So it's the idea that no, rights are based on a philosophy. I know you're familiar with Brad Thompson's work, and one of the things that his recent book on America's Revolutionary Mind, one of the things he emphasized there that was sort of a new thought to me was the extent to which, when the imperial crisis begins, when the crisis between the colonies and the crown begins in the 1760s, Americans tended to talk about the rights of Englishmen and in very traditionalist terms, and then they transition from talking about the rights of Englishmen to the rights of man. As they go on, as they counter these issues and think about them and debate them, they become more philosophical in their orientation, partly because they're realizing, if we're going to separate from England, if we're going to declare independence from England, then we can't just appeal to English history as the basis for our rights. They have to have a more universal basis. So they start talking about the rights of man. So it was a much more philosophical basis. But also the fact that, when they started forming new state governments, as they declared independence from Britain, the first thing they did is they formed new state governments in all the different colonies. And they started doing all sorts of things that threw out a whole bunch of history and tradition. Like in Virginia, they got rid of they put in the first protection for religious freedom, the separation of church and state. They got rid of entail and primogeniture and these inheritance laws that were traditional. So they got rid of a bunch of things that were in northern states that got rid of slavery. They got rid of a bunch of things that were long established traditions. So it was clear that they were not intending to say everything is just based on tradition.
That's right. And the federal, I was looking so cleverly, I was trying to subtly look up this quotation, which I can't find. So I'll just have to recite it from memory. In the Federalist Papers, they say so. They say in the Federalist, is it not the greatness of America that we have not allowed a blind veneration for antiquity to blind us to the needs of our own time and of our own unique place in the world? So the founders were quite open about the fact that they were breaking with sometimes traditions that stretch back into the mists of history. I mean, you mentioned the Virginia Declaration of Rights and its protection for religious liberty. Up until that point, the English common law had respected what was called religious toleration. And toleration said, well, we have an established church, but, as long as you don't go around breaking things and doing things that we think are too bad, we'll let you practice your own religion instead. But you'll still have to pay taxes to the established church, but we won't necessarily persecute you too harshly. And we'll even allow Catholics to own property. That's what Blackstone says. He said, we even allow, can you believe how which is actually
how tolerant we are.
He was right. That was the most tolerant society at the time. Anyway, James Madison, in 1776, James Madison is in his 20s. He's serving on the committee to write the Declaration of Rights for Virginia, along with George Mason, who is this very respected elder statesman. And Mason writes out, we'll have toleration of freedom. And Madison objects. This little pipsqueak college intern guy says, wait a minute, no, not toleration, liberty. And he persuaded them to change the language to utmost liberty of religious freedom. And that was really important. And the other founders comment on this, Thomas Paine, George Washington, and others say, we don't speak of toleration anymore in America because toleration assumes that the government gives us this right. And this is not something the government gives us. This is something that we have because we are human beings. That's a very radical doctrine. And so understandably, people who are conservative, and by that I mean, culturally or temperamentally conservative, necessarily feel a little hesitation toward that. They don't like the idea of such a radical idea. And so you find this appeal. In Justice Thomas's opinions, you find him appealing to history from the Pilgrim's age. He wrote a First Amendment case some years ago called Morse versus Frederick, where he's looking back to the times of the 17th century, which is long before the First Amendment was ever written. I don't see how the relevance of what the Puritans thought of free speech, but anyway.
Well, and somebody pointed out in, I think, the Dobbs decision that Alito refers to, cites some ideas from Edward Coke, another great English theorist. And somebody pointed out, well, Edward Coke presided over witchcraft trials. He was a great British English theorist, but from a very primitive time period when they were just sort of climbing out of the Middle Ages still. That's right. And that's the problem with that, with trying to ground things in tradition, is you are going to, and that's, I think the clearest example, looking at the research on this, and all the debate over what's going on with the Dobbs decision. People are saying, well, what about other decisions relating to privacy and to the freedom of your sexual life? And I realized suddenly that it was only in the 21st century, Lawrence versus Texas, that the Supreme Court said, actually, we can't criminalize homosexuality. And that's something that is so obviously, but we can see it today, that it's so obviously necessary for a free society that no, you cannot criminalize somebody just for that.
And that decision, it's easy to kind of skip over what that decision is really about, the gravity of that case. We're talking about the state sending people with guns into your bedroom to, in the middle of the night, drag you from the arms of your loved one because voters or their elected representatives don't like the way you have sex. That is an incredibly extreme proposition. And until the Lawrence decision, which is, as you said, very recent, the Supreme Court had said that was perfectly fine. And Justice Thomas, by the way, in that case, in the Lawrence case, Justice Thomas said, well, I think this law is really ridiculous, but it's okay with me. So take that for what you will. Well, I think you talk about these other rights, by the way, it's not just sexual freedom, privacy rights, that sort of thing. Take Gideon versus Wainwright, which is a long respected, storied decision of American legal history, which says that you have a right to a criminal attorney if the government is going to prosecute you. That is a substantive due process decision. If you read the opinion, what happens is the court says, look, if we're going to have trials, they have to be fair. Otherwise, you're just tossing a coin, right? Like I said earlier. So if we're going to have a fair process and you bring some civilian you've arrested in off the street and you put him down in the chair and you hold this full criminal trial, most people have no idea anything about the law. It's gibberish to them. It might as well be in a foreign language to them. And so if you're not going to have a kangaroo court, you have to give them some legal representation to protect their rights. Now, is that a procedural right? Or is that a substantive right? It's both, right? And why is it there? Because fairness is what marks the difference between a random coin toss and a real criminal trial. And yet, once again, Justice Thomas has said that he thinks that he thinks Gideon versus Wainwright should be overruled because it's a substantive due process decision.
No, he has a fallback, which is we should depend on the privileges or immunities clause, and that's the one that basically says citizens of the states have the same privileges or immunities as the citizens of the United States. Basically, extends the Bill of Rights to the to protect you against actions by the states. Right. It makes that very explicit. But the problem with that, as I see, is that, again, it says, if something's already recognized, if it's already stated in the Bill of Rights, and there, I think the issue too is the issue of unenumerated rights, right? Because if we have this idea that, well, the founders didn't want us to be recognizing new rights, well, they said they wanted us to be recognizing new rights because they put the Ninth Amendment in there that says, well, we've listed these rights in the Bill of Rights, but there are others that are not listed that you are still protected by.
And if the framers of the 14th Amendment had meant for us to switch over to privileges or immunities, they would have deleted the due process clause, and they didn't. Also, the due process clause protects all people. The privileges or immunities clause only protects citizens. So they are two very different clauses. And Justice Thomas, his big problem, like you said, is that he wants to appeal only to history in interpreting the privileges or immunities clause. If he appealed to philosophy, we have a different issue. But what he's proposed switch, like you said, get rid of due process and only emphasize privileges or immunities. And there's no grounds for that. If privilege of immunity is good and he's right, it ought to be enforced. Why not have both to protect us from the state? That's why they exist.
Yeah, no. The idea that we should have more protections against government rather than fewer protections, but like you said, I think that there is this history in the Supreme Court on both sides that people veer towards majoritarianism or back to protection of rights, depending on the outcomes on the particular issues that motivate them and their ideology and their sort of faction in today's politics.
That's right. Yeah.
All right, so I want to give you a chance to make a couple plugs here because you've written about substantive due process at greater length in another book, and you also have a new book out. So I want you to mention the title of that other book.
My due process book, it's called The Conscience of the Constitution. It's about 8 years old or so. My new book, which is coming out in November, is called Freedom's Furies, and it's not law. It's a history and literature book. It's about the Isabel Patterson, Rose Wilder Lane, and Ayn Rand, who were friends in the 1930s and 40s, and who in 1943, all three of them published books that sort of kickstarted the modern free market, libertarian, whatever you want to call it, movement. It was
they're sometimes called the founding mothers of libertarianism.
That's right. And William F. Buckley called them the Three Furies, and that's where I get my title, Freedom's Furies. That was Patterson's book, The God of the Machine, Rose Wilder Lane's book, The Discovery of Freedom, and Ayn Rand's The Fountainhead. And so I was interested in their friendship and their correspondence, and also like the cultural and political background. One thing I learned that I had not known going in was how very influential Sinclair Lewis was on all three of them. He was the author of Main Street. He was the first American to win the Nobel Prize for Literature, and he sort of loomed over them as this literary and personal friend, by the way. Patterson and Lane knew him very well, sort of loomed over them as influences. And of course, so did Franklin Roosevelt. So my book is not really a biography of the three women. It's more of a biography of their books, trying to look at the political and literary influences that led them to write the novels and the nonfiction work that they wrote.
Well, great. I urge people to check that out. That sounds fascinating. I'm going to be reading it, and I'll bring you back on at some point when we're ready to discuss that. All right. So on the issue of today, I know that any observer of the Supreme Court and of legal history has to sort of, it's been, for my lifetime, has been an endless series of frustrations that the idea of the Supreme Court and of the Constitution as being there as a protection of individual rights has always been, tenuous, and always been, you get a few victories here and you get a few you get relapses there. Do you have a sense of optimism, or what do you think is necessary to sort of reestablish that proper view of the Constitution?
Well, the number one is to buy and read my book. But after that, here's the thing to keep an eye on in the coming years, and that is the difference between Justice Thomas on one hand and Justice Gorsuch on the other. Gorsuch is also a very philosophically astute man. He has a PhD in philosophy. He's studied under some of the great thinkers in the contemporary natural rights, natural law school. And it's very interesting when the two of them disagree. When Thomas and Gorsuch disagree about something, they disagreed about substantive due process a couple of years ago in a case called Sessions versus DiMaia, with Gorsuch on the pro-substantive due process side and Thomas on the anti side. Thomas was saying there's no such thing as a void for vagueness doctrine. Void for vagueness is the rule that if the law is so vague that nobody knows what it means, it's unconstitutional. Thomas doesn't like that. Gorsuch does like that. He says it's implicit in the very idea of law that you can tell what it forbids and what it permits, right? And so therefore, it's not due process of law to throw somebody in jail for something like, doing bad things or some really broad, vague term like that.
Hooliganism.
So yeah, right. And that's the thing to keep an eye on in the coming years is the clash between those two. And it always makes for fascinating reading because they're both very good writers. They're both very, very smart guys. And it's just very interesting from a philosophical point of view, even though it is often very disappointing, as you said.
Okay. Well, thanks for coming on and sharing this perspective.
Thank you for having me. I really appreciate it.
I'm Rob Jasinski. This is Symposium. My guest today has been Tim Sandefur, author most recently of Freedom's Furies. And I'll also have a link in the description of this to his recent article on substantive due process. If you like this, please hit that like or subscribe button on your on YouTube or on your favorite podcast platform. And you can always find more interesting material about the foundations of a free society at symposium.substack.com. Thank you for joining the conversation.